You are watching DHTV from California State University, Dominguez Hills.
Hi, I'm Dr. Pamela Kreiser, and welcome to NCR 525. Today we're going to start the first of a number of sessions we're going to do on the topic of mediation. So before we start, I want to give you a little bit of my background. My background, as I talk to you about mediation, really comes from the area of interpersonal communication and conflict specifically. And so when I was an undergraduate student, I first became familiar with the area of conflict management, or this idea that we have other people that help us with disputes. This happened when I was an undergraduate. I was in a workplace where I worked at a middle school. And one day when I was working there as a supervisor, one of the students came in and said, I would like to get some conflict management. I was very surprised. I laughed and thought, what do we do with that? Like, where do we keep that? So I went to the back room and I learned all about these youth mediation programs that go on in all parts of the country to help children and specifically minor children in middle schools and high schools, more often, manage their disputes. So from there, I became very interested in mediation. And I earned my undergraduate degree at Cal Poly San Luis Obispo. Then I earned my master's degree at San Jose State University, and my master's thesis was actually on youth mediation. And so I was able to look into the schools in the Central Coast and also in the Bay Area and learn about their mediation programs. From there, I had a very high interest in mediation and continued my education, earning my PhD from the University of Texas at Austin, and that is in interpersonal communication with an emphasis in quantitative methods and also a specialization in conflict. So since then, I've taught for about 30 years in this area of interpersonal communication, conflict management, conflict resolution, and quantitative methods. So this course is really going to focus on that key interest that I had so early on in mediation. This is the idea that we have third parties help us with our disputes. So this course is going to be about the theory that comes or is involved in mediation, and then also the applied skills, because I have the bias that if we talk about mediation but we never actually do it or work on the skill development, then we won't really have accomplished much. So in today's session, we're basically going to introduce the idea of mediation. And how we're going to do it is to put it in context with the other types of formats that are out there. We'll talk even a little bit about some regulations that have to do with training in California. And let's just talk about some of those topics we're going to review today. So the first topic that we're going to cover is alternative dispute resolution. The next one is going to be mediation versus arbitration. We're going to spend some time talking about the role of the mediator. We'll consider some theoretical reasons for mediation, some benefits of mediation. We're going to talk about DRPA, which is DRPA, that's Dispute Resolution Programs Act. And we're going to talk about who can mediate in California, and then we'll also talk about some regulations and requirements. Now, this first clip that we're going to review looks at this idea of ADR, and you maybe have read this on the syllabus or thought about this concept that there are alternatives out there to doing court proceedings. And so when we talk about the idea of ADR, we're talking about alternative dispute resolution, and we're talking about the notion that we have some options out there besides mediation, just a whole bunch of options out there that are different from court proceedings. So let's take a look at this next clip that talks about ADR.
12 years after a divorce, what percentage of non-custodial parents talk to their children at least once per week? Your choices are A, 14%, B, 18%, C, 32%, or D, 52%. The answer in about 1 minute. You have options for resolving your conflict: mediation, conciliation, arbitration, collaborative law, and dispute intervention through probation are all options for solving your own conflict. Each of these options includes someone with training on conflict resolution, helping you to find solutions. There are many advantages to solving your own conflict through one of these alternative dispute resolution services. Studies show that parties are more likely to stick to an agreement reached through alternative dispute resolution. You can create a solution to your problem by working with professionals and each other to share information. Once you understand each other better, you can find a solution that addresses each of your concerns and ultimately works for both of you. In most dispute resolution, you also have more control over the process by which you reach solutions. In alternative dispute resolution, you often have control over where and when the meetings are held, what type of process is used, what professionals you will work with, and how you will each share information. You can use alternative dispute resolution processes to resolve all issues in your case, or to reach partial resolution even if a full settlement isn't possible. The information that you share in some alternative dispute resolution options is kept confidential, which encourages settlement. Confidentiality does not apply in all of the options. Mediation, arbitration, and collaborative law are private and confidential processes. Dispute intervention through probation is not a confidential process, and in conciliation, some information will be reported back to the court. Creating solutions that you both buy into offers you an opportunity to rebuild relationships that may be necessary for your well-being and for the well-being of others in your family, including children. The court process can be a drain on financial and emotional resources. An average lawsuit in America can take over 3 years to reach trial or settlement. Dispute resolution moves at your pace, and if settlements are reached early on, you both can avoid the stress and cost of further court hearings. And now the answer to our earlier question. How many non-custodial parents talk to their children at least once per week, 12 years after their divorce? The national average is 18%. In cases that were litigated in court and did not use any dispute resolution service, the average is 14%. But in cases where parents went to at least 5 hours of mediation before going to court, they were significantly more likely to continue a relationship with their children. For these cases, the average was 52%.
You have options for resolving your conflict. In mediation, a neutral will assist you in resolving your conflict. In mediation, you each have a chance to share your concerns, and the mediator helps you to find solutions that are mutually acceptable to both of you. Mediation is voluntary and confidential. In conciliation, a neutral private attorney appointed by the court assists you in assessing the strengths and weaknesses of your case. You each have a chance to share your concerns and explore the options for resolving the matter without going to court. The conciliator will report to the court a list of resolved and unresolved issues, and may also share an assessment or recommendation with the court. In arbitration, you select a neutral private arbitrator who provides a binding or non-binding decision at your request. The arbitrator's decision is made after hearings and presenting of evidence which may be the same or less formal than court. In collaborative law, you are each represented by a collaboratively trained attorney, and everyone works together with a collaboratively trained coach facilitator who serves as a neutral and helps manage conflict. The professional team assists in solving conflict by finding shared solutions that take into account your highest priorities. In collaborative law, each professional focuses on how their specific expertise can help you find solutions. Like mediation, collaborative law is voluntary and confidential. In dispute intervention, a probation officer meets with the parties and their attorneys to identify the issues before the court, explore solutions, and provide recommendations if requested by the court. Information obtained during the dispute resolution process will be reported to the court. Participation in the dispute intervention process may be required in the probate and family court, but but there is no obligation to settle. Parties decide on the terms of agreement, or if unable to settle, their issues are presented to a judge for determination. You have the option of solving your own conflict through any of these different options and presenting your agreement to the judge.
When I take a look at that clip, the thing that occurs to me the most is how important it is for you and I to clarify the roles that we play in communication events. So when I think about mediation, a mediator needs to be very clear about the role that he or she plays and understand the appropriate behaviors that are inside that role. That's the same with if you were an arbitrator, for example. If you're an arbitrator, then you engage in different behaviors that aren't the same as mediation. And then we could also think about adjudication, which is involving a judge, where a judge engages in certain behaviors that are suitable to that role. Let's take a look at this next clip where David Hirsch, who's an attorney, talks about the role of the mediator versus the arbitrator.
Hi, I'm Dave Hirsch, and I'm a trial lawyer. I'm one of the members and leaders of the Berg Simpson, Eldridge, Hirsch, and Jardine Commercial Litigation Department. I try civil cases, and today we are going to discuss a question that I get regularly, which is, what is ADR? You may have heard that term. ADR stands for Alternative Dispute Resolution, ADR. One of the important things to remember about ADR is that it's not the same as going to court. ADR is designed to help you resolve your cases before you go to court. It includes mediation or arbitration and then some other things. But the two large ones that we often talk about when we say ADR are mediation and arbitration. Sometimes people are confused about the difference between mediation and arbitration, so we're going to talk about what happens when you mediate. The key to remember in mediation is that it is a negotiation to try to reach a compromise. It's not a decision that's rendered by someone else. So let's take for an example, if you have a case and you decide that you're going to mediate your dispute, you would select a neutral, a third party, doesn't have a dog in that fight, who would help the parties negotiate to an agreed upon resolution. Anybody can mediate a dispute at any time. You can mediate before you go to court. You can mediate after you filed your case. You can even mediate after the case has been decided by the jury. Mediations involve a third party, a neutral, as I said, and so that usually has an expense involved, and so the parties will have to pay for the time of the neutral. One of the things I've found is that a skilled neutral is able to help parties overcome some of the objections that they have and reach a point where they can agree on resolving their case. There are three things that are really important in a mediation that are real advantages. Number one, it's confidential. Number two, you have control. And number three, it involves compromise. It was alliterated, right? That was pretty good. All right, confidential. Mediations are confidential. It's not like a decision that you have in court because you're going to be in a private place with private parties and you can agree to keep it confidential. Number two, I said it has control. And what I mean by that is when you go to a decision maker, whether it's a jury or a judge, you lose control. Someone else is going to decide about your case. But in a mediation, the parties have control over deciding what they're going to do. Oftentimes, that's a very appealing thing. The third important aspect of mediation, it involves compromise. I've been involved in thousands and thousands of mediations in my career. It always involves some sort of compromise. The best compromise is one where both sides are a little bit unhappy. You may have heard that saying. Mediation allows an atmosphere where you can work together to try to compromise your disputes. All right, so we've been talking about mediation. What's an arbitration? Well, first of all, an arbitration is one where there is a decision maker. So it's kind of like court in that you go to the arbitration, there is an arbiter, an arbitrator, both are correct terms, but a person or people, a panel, maybe three of them, who make a decision. Both sides present their case to the arbiter, and the arbiter makes a decision finding in favor of one side and against the other side, or making a determination that's somewhere in the middle. Obviously, because it's not in court, there's cost involved, so you're going to have to pay for the time of the neutral who's going to make the decision. Number two, you have to select someone you have a lot of respect for because both sides are going to be stuck with their decision. And thirdly, you have to relinquish that control of negotiating and controlling your own case, and you give it to the arbiter who makes a decision, calls the ball, calls the strike, decides how the case turns out. You can have a court trial, a public trial, or you can engage in some sort of ADR, alternative dispute resolution. One of the great things I love about ADR is that you can be creative. What are really the issues that are bothering you? So if you go to court, you're limited to the legal issues. But when you go to ADR, there may be a lot of issues that surround your case, the ongoing relationships of the parties, issues that wouldn't necessarily be legal issues but are very important to people, like maybe apologies or agreements to cooperate in the future. Those are things you can't get in court, but you can get in ADR. Now, I think that every party to a dispute should engage in some form of ADR, whether it's a mediation or even a full-blown arbitration, before they go into court to make a determination. But in any event, hopefully that answers some of the questions you may have about what is ADR. Again, my name's Dave Hirsch, and if you have...
So here you can see that the role clarification is very crucial in any of these formats. Now, of course, our concern for this class is about the concept of mediation. And so as we begin that process, we want to note a few of the terms that Mr. Hirsch talked about that will help us clarify what mediation actually is. So when we talk about mediation, we talk about it as a voluntary process. Now, this is very interesting to think about. Something that I haven't said about myself is I do currently serve as a mediator in Superior Court, and I've done that for a long time. And one of the things that we see is that the levels to which the judge talks about the mediation indicates kind of a different level of voluntary to the people who might choose mediation. What do I mean by that? When we're in a small claims environment, the disputants are required to step outside of the courthouse and exchange their evidence. And when they do that, we offer them mediation services. And so we say, would anyone like to have mediation services? And that appears to those disputants, to the plaintiff and the defendant, to be very voluntary, meaning that they get to choose whether they want to engage in that process. Now, this is a little bit different than when I serve in civil harassment court, for example. One of the things that I've noticed is that sometimes the judge will order a case to mediation. Now, what's interesting about that is he's not ordering that mediation will be the outcome. He is asking those parties to engage in mediation as their first step. And then if they decide they don't want to do mediation, they can terminate that and then go back to the court and have the judge decide their civil harassment case. I find civil harassment to be very complicated, but also very rewarding. In that, it's mostly where a lot of interpersonal problems are talked about, and it really is very much in my strike zone as an area of interest, having a specialization in interpersonal communication and conflict and mediation. So you can see where all of those things come together in that civil harassment court. So when we talk about voluntary, we're saying that when individuals are in mediation, they have the option to terminate, meaning they don't want to solve it in mediation, they don't have to. And so that's how we think about that term voluntary. We also talk about it as collaborative, and that means that everybody works together. One thing that is really a big distinction between going in front of the judge versus working out something in mediation is this notion that when we collaborate, we might come up with solutions that no one has thought of. Now, keep in mind, the mediator doesn't add his or her solutions, but even those parties who have been sitting with this problem potentially for years might come up with a solution that is even superior to something they would have thought about prior to coming to mediation. Different from that, of course, is the non-collaborative process where a judge will ask questions and then make a determination. It isn't a collaborative process. It's a very structured legal process where the judge decides. Now, when we talk about the notion of confidentiality, I think this is kind of interesting to think about. When we talk about confidentiality, I think most people hear that and think, oh, mediation means we don't talk about any of the parts of mediation, it's all a secret. And yes, that is essentially true. But the part about confidentiality that's more important to talk about is the notion that whatever we talk about in a mediation can't be used as evidence in a court proceeding. And so you might read about that in textbooks or in articles. And that, I think, is a more important part of the distinction between adjudication and mediation. This notion that when you and I settle something in mediation, we go through those details and they can't be used in court. So let's say somebody comes into a case in small claims, for example, they choose mediation, they volunteer for it, they start working on the case, and then decide that mediation is no longer suitable. What do they have to do? They have to keep that process separate, and then go to court and start all over again. And so when we use the term confidential, it's not necessarily just keeping the information secret, it's separating the processes. The last part is impartial. And this, I think, is maybe the hardest part for a brand new mediator to do. You and I are humans. We are people who are emotional. We have perceptions of right and wrong. And we face, as mediators, situations where we might favor one of the parties. And whether we have that favoritism operating inside of us, it can't operate in the communication event. So what does that mean for you and I? We have to stay impartial, and we have to make sure that we're fair and neutral. And that is in every part of our language. Now, sometimes I'll see mediators try to facilitate more communication, so they may use phrases like, oh, good, or that's great. But one of the things that I like to teach is I don't think you should use those phrases, because it sounds like you're agreeing with the representation of that one side when they speak. And what I would suggest is that it's important for us to use pauses and not offer evaluative kind of phrasing or terms so that we can stay neutral. I always like to use the gesture of out here, where we do our mediation out here, and you don't make yourself a part of that process. And I'm going to talk about that a little more in a few minutes. The next couple of clips are by an attorney, Jerry Slusky, and he offers some very good insight. Something to know about mediation is that many attorneys over time do explore mediation as an option, as a way to help their clients. So let's hear from him talking about mediation in his law practice.
There is no issue too complicated for mediation. I don't care if there are 8 to 10 difficult issues that are intertwined in the case or multiple parties. The process works. And it works generally in spades. Once we get the parties down, once we talk to them and let them express themselves and start to find out what their interests are, the process works and we can come out with a successful result no matter how difficult the case is. When I walk into the room at the start of a mediation, it's a pretty serious moment because the parties are new to the process. The lawyers are kind of looking to the mediator to shape the day. I do what's called setting the table. It's a mediator's term, where we go over all the rules for that day. And once we get started with each party telling their story, then things start to melt down. We start to get a flow in the mediation, and a lot of really good results come out of that once we get the parties to that point. The fact that they commit to show up for the mediation is huge in and of itself. And once they get there, and after the first half hour or so where they each told their story, they start to get comfortable with it. I think I'm asking enough probative questions of them where they start to feel like we do care and we are searching for a solution to help them find a solution. And once that comfort level sets in, we've got a positive day going. It's important in mediation that the parties understand that what the mediator is doing. First of all, he's neutral, and he states his neutrality at the start of the mediation. He's there to help facilitate negotiation or conversation between the two parties themselves, who end up crafting their own deal. That's a really important part of mediation. It's not trusting the mediator, it's trusting the process. In a successful mediation, the interests of the parties are tapped into, and we use those interests to find a result that's satisfactory to both of the parties. And litigation and the results from litigation don't do that. That's a judge or a jury and a judge making a decision for you that doesn't necessarily take into account your interests. If the parties become a bit adversarial, we meet with them individually and their attorneys if they're there, and we try to get them back to helping themselves find their own solutions to the dispute. And generally speaking, when you put parties in a room, and they express themselves and they get their feelings out, it's amazingly tranquil once that takes place. It opens the doors to a huge amount of opportunity to really dig in and help them solve their problems. As the day wears on and the mediator spends more and more time with the parties and vice versa, I think a mutual respect develops. They know that you know what you're talking about. They know that you've listened carefully to what their concerns and what their issues and their interests are. And once you get past that point of achieving their confidence, then the door's open to a successful result. Another really important thing that comes out of a positive mediation is that the process is totally confidential. And the agreements are totally confidential, unlike a court case that's out in the public. And the parties can go on with their lives with their business reputation secure and strong, and nobody really needs to know what took place except that apparently it was a positive result.
So you heard him talk about the notion of a neutral third party, and this is a phrasing that we're going to use throughout the semester, talking about this idea that this neutrality is the key to the entire process. In a few moments, I'll talk about the theoretical underpinnings of that notion, but in the meantime, let's look at the next clip and see what he says about why people might select mediation from a client standpoint.
I've been in the practice of law now 38 years. I've been with several law firms, all of which had significant litigation departments. I knew the cost in dollars and human pain and suffering of going through a very significant piece of litigation, and I always felt there was a better way to do it. When I was first introduced to mediation about 5 or 6 years ago, I just became passionate once I saw that you could cut through a dispute, break it down into its pieces, get the parties talking to one another, with or without attorneys, depending on whether it's in litigation or not, and to see them after 6, 7, 8 hours come to a resolution and sign up a binding agreement is absolutely the most professionally satisfying thing I've done in my career. The minimum cost of starting out a litigation is about $10,000 to $20,000. And most pieces of litigation will go on for several months, if not years, and will end up costing somewhere between $25,000 and $100,000 per party. Mediation generally gets done in a day, and the cost to each party generally does not exceed $2,500. To resolve disputes in this way is far, far better than anything I've ever seen. Mediation has no downside. Whether you're in litigation or thinking about litigation, to attempt to resolve a dispute through the use of mediation is a totally confidential process. Nothing said in that room can be used in a court of law. And if it's not resolved, then the parties can go on and litigate as much as they want. But at least they'll know that they tried.
So one of the ideas that he touches on is this notion of cost. And when I think of cost, actually, because I do civil harassment mediation, is that there's actually not just the financial cost to think about. Of course, you heard him talk about the extreme difference between the low cost of mediation and the very high cost of using attorneys. But the other thing is to think about the emotional cost. One of the things that I like to say about mediation is that mediation is the process where we are able to have a structured conversation that accomplishes what you weren't able to do before you arrived at mediation. Meaning, somehow the communication has failed. Some feelings were left out, some communication didn't happen, some messages weren't exchanged, some intentions weren't talked about, some honesty didn't happen. And when that happens, there are a lot of high associated costs. So as we think about money, we would also think about what can mediation do to lower the emotional cost for the disputants. This last clip from that same attorney goes over a success story that happened in his practice. Let's take a look.
It's very exciting to me because honestly, I don't think I've ever not been able to convince somebody to try this. This is the way to resolve disputes, and if we don't make a deal, then they can always go to court. I was hired by two ladies who were partners in a business. They'd formed the business and had operated it for about 3 years. And they had built quite a successful business. One of the ladies had no money to put into the business, but put an awful lot of sweat energy. And the other one had the money to put it in. And they both worked shoulder to shoulder, side by side for 3 years and built, as I said, a pretty successful business. The lady who didn't have the money was promised 25% of the company, and that stock was never issued. And in the third year, she asked several times, had her lawyer send a letter requesting it, and it was denied. And as a consequence, a lawsuit was filed by the lady who didn't have the money to get her 25% stock interest. Each of the parties had spent over $100,000 each to prosecute this lawsuit. And when it came in front of a judge here in the district court in Douglas County, the judge had said to them, why don't we try to mediate this case before we have a full trial on the merits of this case. So during the mediation, after I heard both of their stories in the morning, I met with each of the parties and their attorneys separately, and I learned some things that helped me work with them as a neutral to achieve a positive result. What I learned in private session was an interest, a big interest of both of them. And once I knew the big interest of each of them, and I'm the only one who knew it out of the two attorneys, the two partners, and myself. I'm the only one that knew what both of their big interests were in getting resolved there. I get excited about the process because I pretty much know that I can go back in the room with everybody and use those interests as a way to help them craft a solution. The result of this mediation was a huge time saving, a lot of money saved, and as I say, most important of all, these two partners, after 3 years of grueling litigation, came away as friends, and I know that that relationship exists today. Those are good results, and they give a mediator and the attorneys and the clients a huge amount of satisfaction.
So one of the analogies that I like to talk about lately, as I train mediators all the time in my different roles as an educator, I like to talk about this notion that disputants have very unorganized thinking. And so we talk about mediation as a structured conversation, and that the mediator, without adding anything to that conversation, helps provide the structure. And so the example that I like to use involves Legos. And as we look at these pieces that are on the desk right here, we might see that one disputant might bring in all kinds of different elements. Some are big issues, some are small issues, and we might see there's all kinds of different concerns on the part of this first disputant. So the mediator might take these ideas and kind of ask some questions and say, how big are these issues? How small are they? And then let's say this other party comes in and these are their issues. And so we think about it, and we are able as mediators to ask some questions. Now, sometimes disputants don't realize that they have some of the same concerns. So let's say each of these pieces represents like an issue. We would say as mediators, well, did you notice that you both share this issue? And did you notice also that you share this issue? And so what's interesting as a mediator is you're not adding pieces to the table, but you're clarifying that. And so as we think about these different pieces, we may decide that these are actually the only pieces that are important in the mediation. And so as we proceed through it, we can theoretically kind of focus on those areas of commonality. We might also say that there maybe is this additional piece on either side that must be talked about as well. And we might help those disputants become aware of the differing perspectives that each other has, as well as the commonalities. When I think about the theoretical underpinnings of this notion of mediation, I would go all the way back to Piagetian concepts. I would go to Vygotskian concepts. That this idea is that humans think in abbreviated patterns. And so when we talk about humans and their thinking about different problems, we know that abbreviation is a problem of the human condition. And so specifically, Vygotsky talks about this notion that you and I can use elaborated terms and elaborated conversation in order to stretch that thinking for broader understanding. And when I think about the theoretical underpinnings of what a mediator does, that is precisely how the conversation is structured. This notion that you and I can use elaboration when we play the role of the mediator, and we can elaborate on the details, we can ask questions, we can show comparisons, we can show commonalities, but as we do that whole structured conversation, we are facilitating this notion of elaboration that promotes that broader understanding. You have heard a couple of attorneys now talk about that notion as well, that when you and I sit down together, we gain new perspective because of that elaboration. Now, of course, we would want to talk about the benefits of mediation. I mean, you're already thinking some of them now. But let's take a look at this next clip from the Indiana court system that deals specifically with family matters and other forms of mediation.
At the beginning of this video, we noted several benefits of choosing mediation over formal court proceedings in order to resolve your disputes. Some of these benefits include you and the other party can maintain more control over the resolution of your own problems, including which problems you wish to be resolved. Disputes can be settled promptly. A mediation session can be scheduled as soon as everyone agrees to use mediation to resolve your disputes, even before a lawsuit is filed. Mediation costs can be significantly less than taking a case to court. Mediation can promote better relationships through cooperation, creative problem solving, and improved communications. In mediation, you and the other party are more likely to abide by agreements that you created yourselves. Mediation is private and confidential. You, the other party, and any attorneys and the mediator may not tell the family law judge the information discussed or disclosed during mediation. Mediation is voluntary. Although a judge may order a case to proceed to mediation, settlement is entirely voluntary. Also, this process may be terminated at any time during the session by the mediator or by you or the other party after 2 sessions. If you cannot reach an agreement, you still have the right to take the dispute before a judge.
So when we talk about the benefits of mediation, of course, one of the areas that I like to focus on are the 2 areas that I have primarily worked in regarding mediation. One is in youth mediation and the other is in the court system. So let's talk about youth mediation. In many years of consulting the public school system, one of the main benefits of mediation to the students was that it changed their consequences for whatever the dispute was. So it could have been an interpersonal problem, it could have been any kind of game conflict, sometimes that happens in the school, or any kind of school conflict over material or property. We would take all kinds of different cases, and I mean we, meaning the students were the mediators. I was just the consultant. And the thing that's interesting about that format is that when a student chooses mediation in the public school system, they actually don't face the consequences of the vice principal any longer. What they engineer in mediation is the outcome. And so that's actually very beneficial if you're the person who did it, so to speak. If you're the person that is more at fault or could face a higher consequence, that's kind of interesting to think about. Mostly, mediation is honestly favored in both systems because it helps the disputants get to a better place. And that's more valued than our enacting the consequences. So sometimes vice principals don't suspend or they don't give detention or different consequences to students because they choose mediation. And that is in the hopes and the confidence that mediation will have better outcomes for the students. Now in court, it's very similar. So one of the areas in court, if you do any court mediation or you're familiar with it, one of the favor or benefits of mediation in court is that for the defendant, their outcome, if they have a mediated agreement, goes away in terms of consequences. So it doesn't necessarily admit guilt to a crime, so to speak, but it does change the outcomes for that defendant. So let's say, for example, you had a judgment against you for $1,000 for not paying a medical bill. That might be something in small claims. If the judge decides it, then it potentially affects your credit for 7 years. However, if you got a mediated agreement and agreed to pay that same amount, but you didn't go in front of the judge, you worked with the mediator, then that would actually not affect your credit. And so that's kind of a very interesting thing to think about. We talk about the benefits communicatively, we talk about the benefits in time and money and emotional, but one other area to really talk about is the consequences. They are very favored in the school system and very favorable in the school system as well as in the court system. And so we would acknowledge that the more that is the case, the more we find people will choose mediation because it has more benefits. All right, so the last topic we want to talk about is DRPA. And DRPA stands for Dispute Resolution Programs Act. And this is something that was enacted in 1986. And it was essentially when all of the rules were set in place for what kind of training needs to happen in terms of DRPA requirements. So the first question is, what is DRPA? It's that standard that was set in 1986. And second, who can mediate? And so the DRPA law that came into place established what kind of training is necessary to become mediator. And so you'll see in the class documents, I go through some very specific details about this, but I want to talk generally about what DRPA is now and also talk about some of the regulations. So the first thing I want to talk about is some key parts of the DRPA law. So the first thing that we would want to talk about, or legislation, I guess is what I would say, that DRPA was justified because adjudication is very costly and time-consuming, and complex formal court proceedings are part of that process. And so when we do mediation, the intent of DRPA was to help relieve the court system as well as establish some foundations for training. So we know that that's basically the case. We know that our courtrooms are overburdened, and so because of that, that's another reason to make some legislation in place for mediation rules. Also, DRPA established that mediation services have to provide written statements when they get mediated agreements. And so you'll see and hear us refer to that throughout this course, this notion that mediated agreements are part of this process. So we know that most mediated agreements are not enforceable. So that's kind of an interesting distinction. So the other day I was in civil harassment court mediating, and we had that question from one of the disputants. And the disputant said, can I just use this against them if they violate any terms of this behavioral agreement? And the answer is no. But the mediated agreement can be used in a subsequent filing. So that's kind of an interesting distinction to say we don't use mediated agreements as to call the police and say, hey, they broke my mediated agreement, as if it were like a restraining order or something. Instead, we have that mediated agreement as the basis for maybe a future contention against another party. Okay, so let's talk about regulations and requirements. So when DRPA was established, it established this notion that there had to be about 25 hours of course requirements and then about 10 hours of role plays and observations. And so when that was established, basically that meant that the training had to be specific. In the covering of the DRPA law, it's the history, it's the terms, it's the structure of the California justice system, civil and criminal cases. The concept of neutrality, which is something we've already talked about, confidentiality, impartiality, also communication skills, of course, the part I love the most. The idea that there are specific skills of collaboration, negotiation, positive climates, managing emotions, talking about culture, all of these areas we're going to talk about in this class and cover. And then also the required paperwork, which involves intake, it involves settlement, mediated agreements, and anything else that would be established to make that a formal process. So, in summary, today we have talked about mediation in general, and we've identified the concept of ADR, which is alternative dispute resolution, and we've further identified that mediation is one of those forms. So when people say, I do ADR work, or I'm an ADR consultant, they might consult in all of those areas. However, this class is concerned only with one of those areas. That's the idea of mediation. And so as we talk about mediation, we're going to get very specific about what are the processes involved, what are the structures, and then of course the behaviors of the mediator that you and I need to engage in to help not be a hindrance to the process and help disputants get to a better place than when they came to your mediation. And that's really how I think about it. Sometimes I hear people talk about this notion that if you get a resolution, you're successful, or if you get a mediated agreement, you're for the win. And one of the concepts that I would say is I actually don't believe that that is what makes good mediation. What makes great mediation is the notion that you and I are clear about our roles, that we understand the structure and the process, and that we try to help people get to their own solutions. And when all of those things are working, yes, of course, it's more likely that we'd get a mediated agreement, but we don't hold our success or failure on that notion. We hold our success or failure on whether we are really excellent at the process. And so that's what this course is about becoming an excellent mediator and engaging in the process so that you can do the most to help other people. Well, I'm Dr. Pamela Kreiser, and thank you for joining us today on NCR 525. I'll look forward to seeing you next time.